This is the state of Tennessee versus Krystal Nicole Daniels. Ms. Daniels is here today. We are starting the jury selection process, but I've been handed a document indicating that an agreement has been reached whereby the state and the defense have agreed that Ms. Daniels may enter a no contest plea, a nolo contendere plea, to count 1, aggravated child abuse, and receive a sentence of 15 years to serve. Count 2, conspiracy to commit aggravated child abuse, receive a sentence of 12 years to serve. Count 3, false report, 4 years to serve. Count 4, tampering with evidence, 6 years to serve. These would be served at 85%, and they would be concurrent with one another. Is that correct? Yes. So essentially an effective 15-year service sentence that would be served concurrently with one another at 85%. Ms. Daniels, would you please raise your right hand and be placed under oath?
Solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God.
State your full name for the record.
Okay.
Ms. Daniels, I'm going to go over your rights. I want to make sure that you understand what we're doing here so that you fully understand the rights that you're waiving. Do you understand what you're charged with, and have you and Mr. Flanagan and Mr. Wills gone over those charges, and have they discussed with you the range of punishments you're facing as well as any possible defenses that you might have? Well, it's indicated you want to enter a plea of no contest. A no contest plea means that you understand what the state's evidence would be. You understand what they would try to prove at trial. You're not admitting that you did anything, but you're not denying it. And the state may give me facts to support a conviction in this case, even though you have not admitted anything. Do you understand that? And I need you to answer verbally, okay? All right. And do you understand, however, that you have the right to plead not guilty and to have a speedy and public trial by jury? We're in the process of starting the jury selection even now. You understand that? You understand that if you went to trial, you would have the right to have a lawyer. And of course, we've appointed Mr. Flanagan and his associate, Mr. Wills, are representing you by appointment of this court. You understand that? You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state might call to testify against you, and you could bring in your own witnesses by the use of a subpoena? You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and there would be no inference of guilt that would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty of a crime, you could appeal whatever happened in the way of a sentence and the conviction to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. All right. You understand that by pleading no contest, you are waiving or giving up your right to a trial, and all I'm going to do is prove what your lawyer has worked out. You understand that this is going to result in a conviction, and this conviction or several convictions, and these convictions will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. You understand all of the rights that I've explained to you. Do you want to give up your right to a trial and to an appeal and enter this plea of no contest to these charges? Do you understand, or rather, is your decision to plead no contest today voluntary? I understand it may be the best of a bad situation from your situation, but you understand that no one's forcing you to do this. Is that correct? All right. You understand that I can't accept your plea unless I'm satisfied that there are facts to support it and that you are in fact guilty, especially since you're not actually admitting that you've done anything. You understand that? In other words, I have to have facts given to me, and the state's going to tell me what their evidence would be if this case went to trial. Okay? So I want you to listen as the state tells me what they would prove if this case went to trial.
The state's proof in this case would be that on the night of April the 3rd of 2018, that the defendant Krystal Daniels and the co-defendant Joseph Daniels went into an argument at their home about several issues. One would be the actual paternity DNA of the baby Joe Clyde Daniels. They were also arguing about some infidelity in the marriage. That argument led to an outburst that also caused Joe Clyde Daniels to get out of bed. He as the facts would show, urinated in the floor, at which point in time, Joseph Daniels, the co-defendant, did begin to beat and whip the child. The state's proof in this case against the co-defendant, Krystal Daniels, is that she witnessed this abuse and that she saw Joseph Daniels standing over Joe Clyde Daniels with a closed fist and what appeared to be a lifeless or still body. She also knew and was aware that Joe Daniels removed the body of Joe Clyde Daniels from the home and discarded the body at some point in location. Miss Daniels, the defendant and co-defendant Joseph Daniels, conspired and concocted a story to tell law enforcement that Joe Clyde Daniels had escaped from the house by pushing a coffee table to the door, unlocking the padlock, taking the padlock off, moving the coffee table back to the center of the living room, and then leaving the house. This statement was made by defendant Krystal Daniels to law enforcement, which can be seen on body camera. She told law enforcement that baby Joe had in fact escaped the house. Ms. Daniels also relayed to several official inquiries by law enforcement: one, the missing persons report, and two, a lost persons questionnaire that Joe Clyde Daniels had in fact left the house, escaped the house the previous night or in the middle of the night. That would make up the offenses of false report and tampering of evidence. All of these things combined together, as of today, the state's position proof would be that the conspiracy to cover up this crime, this murder of Joe Clyde Daniels, is ongoing because the body has never been recovered. Those would be the facts presented at trial.
Ms. Daniels, I'm not asking that you agree with all of those facts, but do you understand those are the facts that the state would attempt to prove at trial? You still wish to plead no contest? Are you satisfied with your attorney's services? You feel that Mr. Flanagan and Mr. Wills have done a good job of representing you competently? Mr. Flanagan, do you know of any reason she should not enter these pleas?
No, Your Honor.
Anything further from the state?
No, Your Honor.
And Krystal Nicole Daniels, in response to your plea of no contest to count one of this indictment, I find you guilty of aggravated child abuse, order that you be sentenced to 15 years in the Tennessee Department of Corrections. That will be served at 85% release eligibility. Count two of this indictment, you're found guilty of conspiracy to commit aggravated child abuse. You are sentenced to 12 years in the Tennessee Department of Corrections. That is to be served. Count three of this indictment, you're found guilty of false report, sentenced to 4 years in the Department of Corrections to serve. Count four of the indictment, you're sentenced to tampering with evidence. You're found guilty of tampering with evidence and sentenced to 6 years to serve. All of those will serve concurrently with one another, and you're given credit from pre-sentence jail credits of April the 9th of 2018 until today. That's the judgment of the court in this case. Thank you.
Thank you.